To discuss about the good news that it's 150,000 extra green cards starting from October of 2021. Well, it was 135,000 before, according to Charlie, and it's 150,000. It may even go up also. Now, the main question is, how many of these green cards will be going to Indians? We are going to discuss that. We're going to discuss about the immigration reform. Is it dead or is it still alive? The travel ban and what are the things that you need to do if you are affected by it? What are the things that you need to do to navigate the national interest exemption? We're also going to discuss about the should you downgrade right now or should I wait until the priority date becomes current for filing? We also want to tell you the difference between the priority dates and processing timings. A lot of people get confused and saying, my priority date became current. Can I get the green card immediately? Well, there is also called processing dates. We're going to discuss it. The main million-dollar question, Emily, or a billion-dollar question, I don't know, it's so valuable for most of the audiences, is that how many of these 150,000 green cards goes to Indians, though? Last time we said that 90% or more might go to Indians. There are a lot of people who contradicted it, and the question was asked to Charlie, how many of these things will go to Indians? Of course, Charlie is in a very responsible position. He can't just say that, it's going to go to Indians. But when you look into the green cards that have been filed, when you look into the priority dates, though, how many do you, out of the 150,000 green cards, will go to Indian nationals?
Almost all of them, because even though they're going to be, so we have these extras, they're divided up by category. EB1 gets their percentage, EB2 gets their percentage, and EB3 gets their percentage. We still have the 7% cap for all of the countries until we use up whatever green cards are available, and then all the extras go based on not the country, but the priority date, the oldest priority date. So whoever's last in line is going to get that green card, regardless of what country they're from. That's what Charlie said. It's not based on country. It's whoever's last in line. Well, who's last in line across all of the different categories? It's India, because those are the priority dates that are most backlogged.
I'm expecting, according to our calculations, out of the 150,000, at least 135,000 green cards will be going to Indian nationals. Emily, is it like, let's say, for example, Chinese nationals out of the 200, now we know it's 290,000. 290,000 Chinese nationals, 7%, 7.1% or 7% is approximately about 20,000 green cards or 21,000 green cards will go to Chinese nationals out of the 290,000, and the rest to all the other countries, though. So a majority of these 290,000 green cards should be coming to the Indian nationals, though. Even though the 7% limit is there, once there is nobody else in the line, they are going to go back to as Emily has pointed out, the last in line, the person who's been waiting for a longest period in line. They're not going to go to, okay, we're going to give one to Chinese, one to Indians. That doesn't work that way. They have to go whosever priority date is the longest. We looked into it. The Chinese nationals' final action dates is right now, according to the June visa bulletin, they're already in 2018 of September of 2018 in the EB3 and 2017 in EB2. So definitely, if the people who have been waiting for a long period of time seems to be only Indians. Rest all the other country people, it's all current for everybody else except for Chinese and Indian nationals. So they are guaranteed to get at least 20 or 21,000 out of the 290,000, but Indians should get at least 150,000 because technically they are going to get within the 140,000 they're going to get it. The leftovers will all be going to Indian nationals. So it's going to be a huge number of people getting the green card next year. It's going to be a huge number of people getting the green card this year. Poor guys who have been waiting for a long period of time. They've been discriminated so much. Not that any new law has been passed. It's it's because of the COVID effect. You guys are getting the green card. Emily, out of this, according to Charlie, he hasn't clearly described, though, how many green cards are already approved. He didn't release the information. What do you expect? Are they going to use the 262,000 green cards right now for this year?
Yeah, so it really is dependent on USCIS to process them all, because the majority of employment-based green cards are adjudicated by USCIS and not the Department of State. And they're at a very sluggish start right now. But we've seen this before. The exact same thing last year. They were very sluggish. Charlie last year was concerned that there were going to be tons of green card waste because USCIS was not processing them fast enough. All of a sudden, through the summer months, they ramped things up and used almost all of them. So the amount that went to waste last year was quite small. So we do still expect the same this year, even though they may not be at the target where they should be to process 260,000. We do expect them to ramp up the processing and get them all done. They tend to speed up, especially in the summer months. They know that September 30th deadline is coming, and they do try to get them all approved in time.
I've seen a lot of RFEs for medicals that we didn't file medicals. That shows a good indication that they are not going to interview the 485 applicants. We already noticed the people that became current in May of 2021. Some of them already got the green cards. I'm expecting that the people who are going to become current in June, most probably a good significant amount of them might get the green card in June itself though. Even if the EADs are not approved, they may still get the green cards without the EAD getting approved. If anybody who is in the downgrade though, if the final action date has become current though, if the I-140 is not approved, one problem with them is that they cannot technically give them the green cards though. They cannot technically, so you may want to speak with your employer to upgrade your application to the premium processing though. We know that in the first quarter, they may have only adjudicated a less number of green cards in the employment-based. It's always been a practice of the USCIS. They start very slow, especially in the first quarter. First quarter is October, November, and December. Please note that in United States, that is it mostly falls into the holiday season, and they start ramping up more as things progress. Especially in the summer season, they do ramp up very much higher to get the you get those things. So we do expect 262,000, if not at least 95% or 90% of the 262,000 green cards should be allocated to the employment-based and should be approved by September 31st of 2021. Anything else to add, Emily?
Nope.
Emily, with regards to the travel ban, immigration reform, what's going on? Is it dead? Do you think so something is going to pass?
Well, we've talked before about reconciliation, this process of using the budget in order to pass some of the immigration reform because of the gridlock in Congress. Unfortunately, through the press secretary yesterday, President Biden is now saying he doesn't plan on using reconciliation at all for any immigration reform.
That's right.
He's planning on moving forward in a bipartisan manner, which means we're still back to square one with the Senate and the filibuster and things just not moving forward. So it doesn't look good at this time. We're kind of falling back into the same pattern where we were in with Obama and so many times before.
Obama and also Bush, the junior Bush.
Mm-hmm. So it's not looking good right now. He's not giving up on it, but I'm just not sure what pressure he can put on the Senate to move forward with the bills that have already been passed by the House.
Emily, on the travel ban, if I want to get a visa in India, can I just send an email saying that, okay, I work for the transportation sector, for example, for airlines, then I would be just given an exemption for the national interest exemption, and would I get the visa? How does the process work?
Yeah, so it's a little more complicated and longer than that, unfortunately. First, you do still have to go through the regular visa application process. So before you can even start thinking about getting an exemption, you have to first submit your application, the DS 160 application form, pay the visa fee, schedule your interview, even though, if interviews are available in the fall, you get that scheduled. Once you've gone through those preliminary steps, then you have to contact the consulate to ask for NIE consideration. And for that, each process is different depending on the consulate. They may just have you send an email through their public inquiry email. Some consulates have a form on their website that you fill out, so you have to look at your specific consulates. They usually do have instructions online for how to initiate that process. But you first provide them kind of the basic information, and then they'll come back to you and ask you for more detailed information. Some of them have been sending a list of like 30 questions that you need to answer, and then in response to that, you have to provide supporting documents. So if you're saying that your work is providing vital support to critical infrastructure in transportation, you're going to need a letter from your employer detailing how it meets that requirement. And there's no guidelines for this. There's no right or wrong way to do it. It's up to you, your employer, and the attorney to make an argument that's plausible based on it being vital support to critical infrastructure. That's all we have to go with. So once that information is submitted, then you may be granted an emergency appointment. That doesn't mean you've been granted the NIE. That just means they're giving you the opportunity to come in and make your case at your visa interview. So it's possible they may grant that emergency appointment, you go to the visa interview, and then they deny your NIE and still cannot get the visa to come into the US. So it is a multi-step process. It doesn't happen quickly, but if you're successful and you do get that NIE, it'll have a notation on your visa, and be aware that that means you have to travel to the US within 30 days. If you take longer to get your flight and travel details together, the NIE expires and you have to go through the whole process again.
Emily, with regards to the downgrade, a lot of people are asking questions about the downgrade process, which we have already gone through in 2020. A lot of people did went through. Is the downgrade process new? No, it's not new. Look into the Chinese nationals, the visa bulletin though. It zigzags, it goes, sometimes this goes forward, that goes forward. It's nothing new for immigration lawyers. For those new immigration lawyers, it may be new. We've been seeing it very many times. In fact, look into our videos that we did 2 years ago on the downgrade process. How does it work out? So you can do the downgrade. If you do the downgrade, Emily, let's say for example I have an EB2 approval in 2017, and I think so maybe EB3 will move forward. So if I downgrade to EB3, what if EB2 moves forward? Can I still file the 485 with EB2?
Yes, if the downgrade is done correctly, it's a second filing that leaves your EB2 intact. So once you have both applications processed, you have EB2 valid and EB3 valid.
Can you explain what is correctly, Emily? Because just before of September of 2020, there are a lot of YouTubers that came in, and I don't know where they come from. They came in and said that the only way to file the downgrade is by filing as an amendment. Is that the correct way of filing?
No, and that caused so much headache for us as we're trying to get all these applications processed. People decided not to file and then decided to file, and it was a big mess. But you do not want to file an amendment. An amendment takes your EB2 I-140 and makes it an EB3 I-140. You lose the EB2. There's no reason to do that. It is a second filing. The only difference is you're filing with an expired labor certification, and there are questions on the form that ask, are you filing with an expired labor certification? If yes, is it because you have a previous I-140 that you submitted that labor certification? You answer that yes, and you provide the receipt number. You already provide the approval notice for that. They will go and get that original labor certification out of the old file and put it into the new file and adjudicate the downgrade. So you do not want to file this as an amendment.
You don't know anything about immigration, Emily. Since the labor certification has expired more than 180 days ago, how can you file it with the same labor certification?
Well, there is a memo from USCIS that specifically says that you can do that, particularly if you're wanting to file in a different category or classification. So filing a second I-140 with an expired labor certification can be done if your first I-140 got denied. If you got the first I-140 approved and then it got withdrawn because maybe you left that company can go back and file it again and revive it. Or it can be done for a downgrade.
Thank you, Emily, for update. Now, priority date and processing timings, guys. Here is the main issue that will pop up right now. The priority dates are becoming current for a lot of people. Can they contact the USCIS and say, hey, why is my green card not approved, even though my priority date is current, though? Now, priority date and processing times are different, though. If the priority is for a case to be approved, the priority date has to be current, especially for the green card application. Now, the USCIS processing times right now is according to their processing online, though it is 33 months. What does that mean is that if we want to raise a service request, if we want to contact the congressman, they will just say that that application is in the normal processing time, and we will adjudicate it when the time comes in. Although we have seen significantly that the cases, even though are being filed in October of 2020, they are getting adjudicated right now for the 483 application. But if you want to make a service request to the USCIS, you may not be able to do it because their processing times online says it's 30 months. So that's a problem. Right now, even if the priority date becomes current, we just have to sit and do nothing. I mean, there's nothing you can do about it. If you contact the USCIS, they'll say it's within the processing time limit. However, though, for the case to be approved, though, there are things other than final action date becoming current. The I-140 must have been approved. The medicals have to be submitted to the USCIS. Biometrics have to happen. Now, I-140 is in your hand. You can do premium processing. Of course, we know that some of the cases are not getting accepted in the premium processing. I would say about 15 to 20% of the cases are not getting accepted in the premium processing, but the rest of the cases are getting approved in the premium processing. Also, if you have not submitted the medicals, you may contact your lawyer to submit the medicals. When it comes to the biometrics, that's also need to be done. Right now, we are clueless, guys. I mean, we have no clue on what's going on in biometrics. Of course, some of our clients got the biometrics. When these clients are speaking with EMA and USCIS, we are getting a response from them saying that they are using the biometrics that were being done at the time when they got their stamping done, maybe it been 10 years before, or at the time when they entered into the United States. At this point of time, we don't have any official information from USCIS that they are going to use the biometrics done at the stamping time or when they enter into the United States. I hope they do it. Online, when you chat with Emma, she says that they are using it. We have yet to receive any official information from USCIS that they are doing it. So it's a little bit itchy thing that we have. But as far as the biometrics is concerned, though, there is nothing you can do. If the biometrics notice have been issued, of course, you will go for biometrics. If it's not done, we can't force them to do issue a biometrics at this point of time. Anything else, Emily?
All right, I think we can go to some questions now.
Questions people are asking is that, oh, my priority date is 2018. I am getting a better offer. And obviously, I'm assuming that they are from India, because otherwise, most probably would have filed a 483 application. If I were you, if my priority date is 2018, I am not moving right now. I am not moving right now because I am expecting the priority date to become current. If you move to a new employer, though, the new employer, by the time he files the prevailing wage, by the time he gets the recruitment process, by the time he files the POM application, gets an I-140, it may take at least 1.5 years to 2 years. In the meantime, if the priority date goes forward and you are not there to catch the boat, it may take sometimes decades, if not generations, to get into the 485 application. Believe me, why would I say generations is that we are not expecting COVID to continue next year. We're expecting COVID to be dead. That is my expectation. I may be wrong. Now, what happens if you look into the articles written by Emily and me that it's going to take 108 years for the persons who are filing green card in 2018 to get the green card? Then a Cato institution, which is a very prestigious institution, used the same logic as what we used. They said we are wrong by 42 years. And they proved that we are wrong. They said it's not 108 years, it's 150 years. Now, obviously because of the pandemic though, the wastage of the family immigrant fell into the employment. The employment-based immigration that were not used by the other country are coming to Indians. That's the reason you're advancing. So do not expect this to continue forever though. So the opening is going to be in October. That's our expectation. Yesterday, Charlie clearly said that he's expecting USCIS to use the filing dates when in October, when he's going to issue the visa bulletin for October, he's expecting it. So if you miss that date, I don't know, maybe if your prior date is 2017, 18, who knows, it may be another decade or maybe in another generation. Maybe your child will become 21 and get you the green card faster. That could be possible if the child is born here, than actually getting the green card through the employment-based. So I would not like to leave the opportunity of October of 2021 to your date. Now, a lot of people, I see the questions here on there, should I downgrade or not? Personally, if I were you, I would do the downgrade application. Having said that, if your employer is not willing to downgrade, and he's telling you that he will downgrade when the priority date becomes current, don't fight with the employer. Because remember, it's not going to be Rahul Reddy, it's not going to be Emily Neumann who is going to actually file the 485 application. It has to be your employer has to give consent for everything to file the 485. You can't go with your own lawyer to do all these things. It has to be done by your employer. Don't fight with your employer if he is willing to do the downgrade at a later date. Now, if the company is not willing to do the downgrade and is not willing to do the downgrade at a future date, you may pull up with a couple of employees together and discuss with the HR and try to convince them. And there are the good law firms that we know, the top two law firms, which I don't want to name them. They're very good law firms, and they recommended all their clients to go downgrade the application. And there are some law firms that I don't know why they have a fear or they don't understand the law. They did not agree for the downgrade. So you may pull up with other people and try to speak with your HR and say that downgrade isn't good, because if they file the 485, they don't have to file your H1B, they don't have to file your H4. Every time you move a location, they may not have to file any amendment. So there are a lot of benefits there. And there's one other thing that you can convince your HR, oh, it's expensive for them. You can bear the expenditure. Legally, an employee can bear the expenditure for downgrading the EB2 to EB3. The employee can bear the expenditure for filing the 485 application. You can request them too. But let me tell you one thing, everything has to be done with your employer's approval only. So having employer's approval is absolutely important for you. There's no option for you to just go outside and get anything done.
I want to give a quick update on the Schedule A I-140 downgrade situation, particularly for physical therapists. We have filed some downgrades in October. At the time, there's no guidance out there. What makes the Schedule A I-140 different than a regular perm-based I-140 is we don't actually file a perm with the Department of Labor and get it certified. We file the form, but we file it directly with USCIS. We submit the notice of filing to USCIS, not DOL. We submit the prevailing wage determination to USCIS, not DOL. So when we're filing these downgrades, we're saying that we're reusing that labor certification and notice of filing and prevailing wage that we submitted before. And you should adjudicate this just like you would any normal downgrade. Well, they're coming back and saying, no, send me your current prevailing wage determination, your current notice of filing, and a new labor form. They're basically treating this like a brand new application. So we're seeing notice of intent to deny, asking for those documents. Some are reporting getting denials, particularly after upgrading to premium processing, straight denials without even the chance of providing an explanation or a response to that. So there is a good chance that those that are pending as downgrades for Schedule A might get denied. And if you filed your 485 along with it, that 485 might get denied. What can you do today so that you can actually take advantage of this possibility in October of this year so you don't miss the boat? You can talk to your employer now to see if they'd be willing to submit a prevailing wage request now. Because of the amount of time that's taking, 5 months, we're currently in May. If you can get that in October, you can file how USCIS wants you to file, but file it in EB3 instead of EB2. You have a new prevailing wage, you do the new notice of filing, and that at least gives you the opportunity. But you have to get that prevailing wage submitted now so that you have the opportunity in October, because as Raul said, this is not expected to go on. October, November, maybe December of 2021 is probably going to be your last chance to do this downgrade and benefit from it for who knows how long, decades potentially.
Dang has this question for me. He's saying that isn't it a bit discriminatory? There are many non-Indian foreigners in the same boat that are waiting for the green card. There are none. I mean, look at the stats. If the priority date for the non-Indians, other than Chinese nationals, it's all current though. So when this extra 135,000 out of the 150,000, most of them are going to Indians, is because they're the only people waiting for such a long period of time. So practically, this is a way of taking discrimination off. I would rather want it legalized, but unfortunately that didn't happen. But it's definitely there's nobody else other than Indians waiting. And if there are anybody else other than Indians waiting, they will get the preference, except the Chinese nationals, which will be given equal preference. But if there is any other national other than Chinese national, they will get preference over Indians in the 150,000 green cards or the 290,000 total green cards that are available next year.
Vijay Kumar from YouTube wants to know, how long does the H4 approval take after biometrics are done, specifically for the Nebraska Service Center? I don't have specifics on each service center, but I can tell you we're keeping tabs on this as part of our ongoing litigation efforts. And just on the data from yesterday, once the biometrics are done, it ranges from 1 day to 273 days to get the H4 approval. So the biometrics is not the only problem. USCIS is using that as an excuse for their incredibly long processing time. There's no rhyme or reason to it. They have no explanation for it.
Harry has this question. If I marry a US citizen, after I get my EB2 green card approved, how long will I have to wait for my citizenship? Harry, it's 3 years if you're married with a US citizen. It's 3 years after the marriage, you will be eligible for citizenship. But technically, you can file 90 days before the 3 years. You can start filing But it's not the amount of green card that you have. It's the 3 years time that you're married to a U.S. citizen. Plus, that 3 year period also, you should have a green card at that period of time. So both conditions need to be met to apply for the citizenship.
Bimal from Facebook wants to know, can we submit the medical sealed package to USCIS in advance of getting an RFE? Yes, that's what we've been talking about, this interfiling. That is one thing you have in your control. If you filed your 485 without the medical exam and your priority date is current or getting to be current, and you don't want to wait for that RFE, you can try to submit that medical now through what we call an interfile. You have to send it to the service center where your 485 is currently pending and ask them to add that to your file. reason why some people are suggesting not to do that is because without having that RFE document and the barcode to scan to make sure it actually gets into your file, it may not actually make it into your file. You could still get the RFE asking for the medical. But a lot of times it does make it into the file, and you can avoid the RFE and you can get a straight approval. So I think it's worth it. You know, the worst case scenario is you got the medical done, you submitted it, and then you get an RFE asking for the medical. You have to get it again from the doctor and submit it again. That's not really that big of a deal to me if it gives me a good chance of getting the green card faster and avoiding that medical completely.
Even if it costs extra $400, $500, if I were the client, I would be willing to bear that expenditure for the medicals to resubmit again. So Ninja Muri has this question. I recently got my GC approved. Do I need to, I changed my address. Do I need to file an AR11? Yeah, you can file an AR11 online. But let me tell you one thing though. There's more fraud happening with the AR11 scare. There are people are getting emails from they say from the USCIS, but we have confirmed it's not from USCIS. And they are scaring people. You didn't file the AR11, now we are going to come and arrest you. There are a lot of those scammers that are trying to, please don't entertain those people at all. Don't pay any money to them. If you get any call of them, please contact an immigration lawyer. You can detect that they are scammers though. As of today, not a single USCIS official has ever detained or threatened to detain because they didn't file the AR11 form. So if anybody did it, that mostly 99% of them, it is the scammers. Be aware of them, okay? And they're going to tell you that we are going to arrest you right now. I'm sending it if you put the phone off. They won't allow you to put the phone off. That means it's definitely a scam. Be careful on that. I got some questions with regards to the birth certificate. The name has been misspelled. Sometimes the parent's name is misspelled. Some of the people don't have a birth certificates. It may be right time for you to obtain the proper documents if you can. I want you to type in, I do not have birth certificate, rnlawgroup.com. Type this one in the Google and then you'll get to an article though. So if by any chance the birth certificate's names are misspelled though, I always want you guys to get affidavits of birth and explain it to the officer that that there is a misspelling in there and you can try to correct it and they can correct it. Get some affidavits explaining that this is a proper name and get the affidavit and submit the affidavits along with the birth certificate. If it's a parent's name is misspelled, I would not bother submitting anything unless there is an RFE. At that point of time, I would submit an RFE. Mostly, we may not receive any RFE if the parents' names are misspelled. So I would not do anything. If by any chance the date of birth is wrong, I want you to contact a lawyer. I just don't want you to submit the wrong date of birth on the birth certificate. It's going to cause a lot of confusion. I would recommend that you contact a lawyer before you submit anything to the USCIS. And this is the right time for you to look into all those things. In fact, our office is providing for the people whose companies are willing to allow us to file the 485 and downgrade applications. We're preparing the applications right now and making ready for October. Because according to our expectation, this boat may not be there unless the COVID continues for a long period of time. This boat might not be there for a long period of time. So we are preparing the application, make it ready, and then we can just file the application maybe on the first week of the first week of October. We're not charging the entire money right now. We're only charging very nominal expenditure. The final, the full money, we're going to request them when the filing dates become current, when we are able to file the 485 application. Of course, we're going to send them an invoice for the full amount, including the filing fees. Only when they pay the full amount, we're going to file the application. Right now, we're only taking a token amount to start working on the I-485. And for some people, we're also doing downgrade applications, filing and getting their EB3 approved and make it ready and keep it ready. And whichever comes first, whether it's EB2 or EB3, we will be able to file the 485 application.
Prashant from YouTube's spouse has an H4 and H4 EAD pending and also filed a downgrade with a 485, and that EAD has been approved and wants to know if she can start working using the 485 EAD. Yes, there's nothing wrong with that. She is authorized to work based on that EAD, but it will make her married to the adjustment of status. That by itself is not necessarily a bad thing, but it's something to consider if your I-140 downgrade is still pending. You want to make sure that you have a good likelihood of the I-140 being approved so that the 485 can be approved. If the I-140 gets denied, that's one of the top reasons why a 485 gets denied for employment-based applicants. And if she gets married to that 485 EAD and then your 485 gets denied because the I-140 downgrade has been denied, it puts her out of status. So that would be the only caution there. But yes, otherwise she is authorized to work using that EAD.
Gopi Krishna and a couple of other people are asking, hey, will the priority date of 2020 be current in 2021? According to our estimates, it may not be current. But if you go back and search our track record and how we predicted the dates, particularly in August and September of 2020, we went very wrong. MD predicted only until 2012. I predicted until 2013. We both were utterly wrong. Hopefully Gopi Krishna and some other people here, including Thiru Navakarasu, hopefully we are wrong again.
Tejas from YouTube wants to know if folks downgrade and file the I-140 and EB3 now, what happens on October 1st if that I-140 is still pending? Can the 485 be filed with a pending I-140 rather than a concurrent I-140? Absolutely yes. You just need to submit a copy of the I-140 downgrade receipt notice as well as the approved I-140 notice showing what the actual priority date is so that USCIS and the mailroom can see that your priority date is current in the EB3 category based on the EB2 approval.
Kishore has this question. If my employer has a perm approved and if the priority date is current, can I file I-140 and 485 at the same time? Absolutely you can. No problem you can. Mandeep has this question from YouTube. Is it possible to apply I-140 in both EB2 and EB3 category at the same time? You can. We're doing for a lot of people right now because they don't know which one is going to move fast. And if you go back to the history of the Chinese nationals, though, it's just, we can't tell which one goes fast. And a lot of people come to us and ask the question, they're spending like $400 for consultation. Just ask one question, which one will go forward? Believe us, no, we can't give any different answer, guys. Even if you pay us a consultation, it's the same thing. I mean, we'll tell the same thing. We can't tell it. The best solution that I suggest people is give your spouse the coin and tell him or her to pick EB2 or EB3. Let them toss it, whichever comes it. You take that. That's up to you. And then if something goes wrong, you can blame the spouse, not me. That's all. Yeah, it may be a good idea for people to have EB2 and EB3 approval because now you have a ticket to go on a horse, you have a ticket to go on a donkey. Whichever comes faster, I don't care. I just have to go to the destination. Whether I go on the horse or donkey, I don't care. You have two tickets to go. So one with a horse, one with a donkey. You can go whichever you want. Yeah, I would like to have the option of EB2 and EB3 right now.
Arjun from YouTube wants to know, when do you think folks with a current priority date and completed biometrics can get the green card in the current timelines? I mean, we're seeing people who filed in October getting the green card now in that situation. I can't guarantee that everybody whose priority date is current in the month of June and has their biometrics done, if they filed in October, will receive the green card in June, because it's really up to the individual officers and each service center. It seems to be going faster for the ones that are at the National Benefits Center compared to those that are at the Texas Service Center, but it really could be any time. Once you have your biometrics done and the final action date is actually current, assuming your I-140 is also approved.
question on with the if the priority date is current, can I file 485 application when I'm in India? The answer is no. You can't file the 485 application when you're outside the country. The only way to do it is that either you come here into United States on a H-1B or L1 or other visas that are eligible for, and then apply for the 485. The other way is to convert your I-140 into consular processing. It's a very lengthy and very time-consuming process, though, and you may also have this kind of dates moving backward, forward, backward, forward. We'll have a lot of problem in the consular processing. Yeah, you can do the consular processing. You may, I may request you that if you are going to stay there and not come into the United States and want to process a green card, I would recommend that you do, you consult a lawyer before you embark on any journey.
Jasmine Joe from Facebook wants to know, can a new employer file a transfer of an H-1B approved for consular processing that has not been stamped? This is a different employer. It will most likely be denied. USCIS takes the opinion that a consular processing approval is not counted in the cap until you actually start H-1B status under that approval or have gotten the visa stamped. So without that visa stamping, it's likely to be considered that you have not been counted yet, which means you can't file a transfer. Swarali from YouTube wants to know, my son is going to be 21 years old. We haven't received his F1 yet. We applied back in September 2020, requested an expedite, but USCIS rejected it. What can we do? So your son needs to file a change of status to B2. So I'm assuming your son is on an H4 or an L2 and going to be aging out when they turn 21. So you have to file a B2 bridge that will allow his status to continue after he turns 21 until the F1 gets approved. Hopefully you only have to file one of those, but make sure it gets filed before he turns 21.
Santil Kumar has this question. Most of the folks are working on EB2 to EB3, and once they work on EAD, what if the EB2 moves forward? Can I use that to get the green card? Yes, if you're working with the same company, you have not moved out of the same company, the company can do the interfiling with EB2. It's not a very smooth process, though, the interfiling, especially when it is a EB3 to EB2, because they have to change a lot of different things. I have noticed that, sometimes, especially when I work with Chinese nationals, is that right? Okay, now EB2 moves forward. I send them to EB2. After so many requests, though, they finally have the EB2 reflected there. Guess what? Now EB3 moves forward. It happens. So I want to be a little bit judicious, and I want to be careful when I'm doing interfiling from EB3 to EB2, though, because I don't want, then everybody will go to EB2. Then guess what happens? EB2 gets backlogged, then EB3 moves forward. Then the whole process might take a long time. So unless, it is taking a very, very long period of time, I would not just try to do interfiling to change to EB2.
Anand from YouTube wants to know, should interfiling the medicals be done by the corporate lawyers, or can this be sent directly by the applicant? So the 485 application is yours personally, and so you can contact USCIS on your own behalf. You don't have to go through a lawyer. You can go through a different lawyer as long as that different lawyer submits a G28 to allow them to represent you. Abhilash from Facebook wants to know, is there any chance perm processing will be faster? Right now it's taking 6 months. I doubt it. I don't think it's going to get any better. I think we're having more and more perm applications filed because of all of the frenzy regarding priority date movement and people who have changed employers now realize they need to hurry up and get their perm approved so that they don't miss the boat. So with that additional applications being filed, as well as lack of budget, there's no filing fee paid to DOL for this to be processed. I would not expect them to get better.
Many questions are coming with regards to At this point of time, only 100,000 green cards have been approved in the employment-based. How can they approve the 160,000? Some people are telling the first quarter is only 23,000. Well, if it's 100,000 in the second quarter, that shows that it's 3 times in the first quarter as the second quarter. That's one variation, though. To strictly going by the words of Charlie, though, he clearly said yesterday that every month they do have a meeting. I don't know whether it's a virtual meeting, phone, or Zoom meeting, I don't know. They meet and he gets the numbers from the USCIS, how many cases are pending, how many, with what he gets all the figures, he said. He didn't explain very clearly. He also normally gets an estimate of how they are going to work. Based on that, he's going to move, is my expectation. He's a very intelligent guy. He's getting younger, though. That's a surprising thing. Last time when we had a lunch with him, he's now, after 10 years or 11 years, he's looking more younger now. He's a very smart guy, and he understands when the USCIS, how it processes. Based on that, he moves the priority date. So I do expect, and I do have full confidence in him that he will be able to use it. He has a knowledge of it. And the USCIS might have given some assurance that they're going to speed up the process. That is my expectation, though. Yeah, there are sometimes he gets very mad on USCIS when they don't behave properly. That's what happened in 2007. All of a sudden, Charlie just moved all the priority dates to be current. Yeah, he has an authority to do it if the USCIS doesn't behave it. That's what happened in 2007. We do estimate, based on his every month speaking, that he has good confidence saying that the most, if not all of the numbers will be used. So I do have the confidence, and yes, there is a difference between the first quarter and second quarter. There will be a difference between second quarter to third quarter, and there will be a difference between third quarter to fourth quarter when it comes to the adjudicate of the 485. It has been historically been the same thing. The third quarter and fourth quarter, you do see a lot of movement coming up in the adjudication of the 485 for the employment-based.
Mahesh from Facebook wants to know, as per current trends, when does USCIS send the RFE for the medicals? Is it only after the final action date becomes current or before? USCIS does a pretty good job of this. They keep track of when they think the date is going to become current, and a few months before is when they usually start looking into the file and sending out the RFE for any missing documents such as the medicals. So yes, they've been good about that. They don't wait until the date is current before they even start looking at it. They do pre-adjudicate these things in advance.
In the continuation of the pre-adjudication, though, Arvind has a question. Will it take 1 year after it becomes current? Hopefully not, Arvind. Hopefully not. But the problem is that there is nothing we can do about it. A lot of my clients call me, my priority date is current in June. Do something. Get me the green card. It depends on the officer, how much load the officer has it. It may, it's not like I do like this and then I get the green card. That doesn't happen. But we don't have to go with the, I don't believe in the processing timing, especially when it comes to the employment-based. They're much faster, though. I believe they're much faster in the processing. And once it becomes current, most of the people should get the green card pretty quickly.
Rishi from YouTube says him and his wife both have filed PERM applications separately with their separate employers and wants to know, will there be any conflict in the green card processing? What exactly is filing with a dependent and without a dependent? No conflict at all. You both can receive your own PERM approvals. You both can receive your own I-140 approvals. When it comes to the 485 filing, that's when you determine who's going to be the main applicant and who's going to be the dependent, and that's usually based on whoever's priority date becomes current first. And if after you filed that, one person is the main applicant and the other is the dependent, if the other priority date becomes current and you're still both maintaining your non-immigrant status and you want to file with the other one too, you can do that too. No issues at all.
CSPA question, Rahul, reply for it. This is Natural Yogi from YouTube. EB2 denied, then apply for EB3. Total time for I-140 after a couple of denials in EB2 is 1 year plus few months. That's not the way we calculate the CSPA. It is the underlying I-140s. You know, people may have 10 I-140s. Maybe you had an I-140 with previous company. Maybe you have an I-140 with the current company. It is the underlying I-140 period that will be counted for the CSPA. So if you have an EB2 that has been pending for 8 months and got denied, and then you filed an EB3 that got approved, and you're using EB3 to file the 485 application, how long did the EB3 I-140 pending? That time will be deducted from your child's age.
Tippy from Facebook wants to know, can we do an H-1B extension while I am in India? Yes and no. Technically, it's not an extension. An extension means you're filing an H-1B petition and requesting USCIS to extend your stay because you're in the U.S. in a non-immigrant status. That means you're asking them to give you a new I-94 for your extended period. When you're outside the U.S., you are not in any status. So there's no status to extend. So you're not filing an H-1 extension, but your employer can file an H-1B petition for consular processing for the additional time that you have remaining on your 6-year limit, or if you have an approved I-140, that priority date not current, they can do a 3-year H-1B for consular processing. As soon as it's approved, you get the visa stamped whenever you can and come back to the U.S.
My wife Vinod has this, Vinod Yamad. The Telugu last names are very confusing, guys. My wife has a birth certificate, Indian native language. Will the translation be accepted by the USCIS? Absolutely. However, the translator has to do a notarization. We have provided a link at the bottom of the Facebook and YouTube, guys, and it has the format of the affidavit that need to be written and signed by the person who's translating. If you or your wife is familiar in that Indian language and English, you yourself can translate it, but you have to sign the notarized certificate of translation. The draft of it is provided in the link that I put it at the bottom that you can look into.
Purnima from YouTube says the priority date is November 2012. We applied for the EB3 downgrade and premium, and now the I-140 is approved. Can we expect that the I-765 will be approved along with the I-140? I think a lot of people are confused and think that the I-765 is somehow related to the I-140, and it is not. Completely separate. What qualifies you for an I-765 is simply having a pending 485. It has nothing to do with whether the I-140 is approved or not, whether there's an RFE on the I-140, whether there's an RFE on the 485. Simply having a pending 485 qualifies you for the EAD approval. So you have to be looking at the I-76 processing times to see when you would expect to get your EAD.
Couple of questions came from Srikanth, Akula from Facebook, and a couple of other people from YouTube. What are the probabilities for the I-140 downgrade to be denied? And there are a couple of people who ask questions on the ability to pay. Ability to pay is that the company has to show that they have enough money to pay the salary which is being given in the prevailing wage. Let's say the prevailing wage is $100,000. There are two ways of showing that they have the capacity to pay the $100,000. One, if they're paying you $100,000 continuously, they are fine. The ability to pay is not an issue. If they are not paying, will the company's income tax returns will be sufficient enough to cover the deficiencies of your salary payment? So if you're getting $80,000, do they have $20,000 profit? Then what if they filed 20 I-140s? For all 20 I-140s, they have $20,000 down, which will be approximately around $400,000 profit. So do they have the $400,000 profit to cover for all 20 people? Sometimes the USCIS questions all these things. So if they have the capacity, then you should not have any problem on the ability to pay. Naturally, other than if you're working for the company though, and if you're filing for the downgrade though, the chances of getting the downgrade denial is way less. I would say anywhere between 1 to 3% of the time. Of course, it depends on the situation. So lawyer will be able to judge it very carefully to see if it's something that he wants to take risk. You know, I had a consultation recently where EB2 was approved fine. It requires 24 months of experience. Unfortunately, this guy had only 23 months of experience before joining the company. Now when he filed an I-140 application, the USCIS is pointing out, look, you had only 23 months of experience, not 24 months, so we will deny this I-140 application. That's definitely a problem. It may actually go back to EB2 also once this denial comes in. So a lawyer will be able to judge it out to see if everything looks okay, if there's any problem. They should be able to judge it very easily to see if there is any potential problems for the EB3 approval.
Punkage from YouTube says his lawyer is saying that the I-693 is only valid for 2 months. Is it 2 months or 2 years? Technically both. The I-693 has to be submitted to USCIS within 2 months of when it's been signed by the doctor, otherwise it's considered to be expired. Once you submit it to USCIS timely, then it is valid for 2 years.
Manoj has this question. My wife and kids are in India right now. If the date becomes current, should they be here to file the 485 application? Yes, they have to be here in United States to file the 485 application. If you're going to file, there are ways where you can file the 485 application. They can still come if you maintain your L or H1 visa. They can still come on L2 or H4 or dependent visas, not a problem. But there are a lot of complications that will be there. Can you join them later on? Depends on if the priority date will be there or not. If the priority date backtracks, you cannot join. What if the priority date backtracks and you can't put them in 485 application, and then what? You use the EAD, they're going to go out of status. So it would be better if they are in United States, and if they cannot come into United States, you may want to consult a lawyer to see what are the other possibilities that you can do to process, to plan your life.
Joyo from YouTube wants to know, can we apply for the L2E80 renewal if my I-129S and visa under the blanket L have expired, but I have a valid I-94 until next year? That gets a little tricky because your I-94 may have been issued in error for that extra time. They're supposed to only give you the I-94 until the I-129S expiration. So you may need to talk to your company's attorney and see if anything needs to be done regarding your own status, in addition to dealing with the L2E80 renewal.
Anything else, Emily?
I think that about covers it for today. Thank you so much for joining us. We'll be back next Tuesday at 5 o'clock Central Time. Be sure to subscribe so you'll get updates whenever we're live on YouTube as well as on Facebook. And if you didn't get your question answered, remember you can always go to our daily Zoom by going to rnlawgroup.com.
Thank you very much.